Good afternoon, class. Today we're going to go over Chapter 12, Courts and Multiculturalism. A lot of good stuff in this chapter. It kind of breaks down the court system, how the court works, very easily for you to understand. And there will be some terminology that we'll go over also. So again, we'll get into the multicultural aspects later in this presentation that has to do with ethnicity and gender in the court system. So first of all, the steps in the courtroom or the criminal trial. And these are the steps, and you should know these. These are basic understanding of the steps in the system of what happens during a criminal trial. We've kind of gone over these at the beginning of class, but this is just more detailed about what happens once you are in a courtroom as a person that is charged with a crime. First of all, there's a jury selection that is supposed to be taken from the peers of the person. Basically, a jury is supposed to be the makeup of the community. So hopefully there's a wide range of persons on the jury, whether it's African American or Hispanic or Caucasian or Asian or other, and a different amount of genders. So it's supposed to be a selection that represents a cross selection of the community. Second, we have the opening statement. First, the prosecutor has an opening statement, and then the defense makes their opening statement. Some opening statements can be as little as 2 minutes. Others are longer. The opening statement for the O.J. Simpson trial took about 5 hours. So opening statements vary in how long they are. Next, we have the presentation of evidence that is done by both sides. The judge's charges, or basically the judge's orders or discussion of what the jury is supposed to do, that's given by the judge. The jury deliberates. They go to a room or an area with just the jury, and they make a decision on the guilt or innocence of a person. They weigh the evidence. The verdict is read either by the judge or the court reporter, and it's either going to be guilty or not guilty, or it's going to be a hung jury that the jury could not agree to convict somebody. And finally is the sentence, and that is where the judge or the jury comes up with the sentence per the penal code. So those are the steps. There's one step that's actually not here, and that's going to be the appeal. Because if you didn't make a plea bargain, then you can appeal your sentence. So those are the steps in the criminal trial. There's the appeal. So kind of know those, how they go, how they work. Next, we're going to look at the initial court appearance, also referred to as the first appearance. And we're going to ask you a question here. So the person has been arrested and they are booked into jail, and they're brought before the court within how many hours of arrest? How many hours do you think it is? 2 hours, 10 hours, 48 hours, 72 hours? How long of a time is it? It is actually 48 hours. So hopefully you don't get arrested, or a person doesn't get arrested on a Friday and a Monday's a holiday, because then it'll be a little bit longer than 48 hours. So it's brought into the court within 48 hours of arrest for their initial or first appearance. As you can see, the next phase or action that's done is that the person is informed of the formal charges against them. Here is the penal code sections that you are being charged with: robbery, penal code 844, etc., etc. They are advised of their rights, including the right to retain a lawyer or have one appointed for them if they cannot afford one. At this time, they can be granted pretrial release, depending on the charges, depending on their prior history. A judge can grant that. They can have an ankle monitor, they can pay a cash bail, they can do a lot of different things to be released before trial. They're made aware by the court of the upcoming steps in their case, what's going to happen next. The judge will talk to them about that. there's lots of rights that a person has that we have in a courtroom, and we're going to go over some of those right now. The book does a good job talking about these rights. First of all, this United States Supreme Court ruled that all who enter our courts have the right to counsel at critical stages of the criminal justice process. So Gideon versus Wainwright was a very important case that ruled everybody has the right to counsel. Prior to Gideon versus Wainwright, only defendants in federal courts had the right to counsel. So Gideon versus Wainwright established everybody in all courts, state court, county court, municipal courts, federal courts, have the right to counsel. So Gideon versus Wainwright was a very important decision that was made. The preliminary hearing or the grand jury hearing. Preliminary hearings and grand jury hearings, you can read about those. They're a little different. There's not a lot of grand juries that we have in California. I think only 2 counties use the grand jury system. But between the grand jury and the preliminary hearing, it's basically the same thing. Primary goals are the same, to determine if the accused should remain in the system and go forth with the court trial. So the preliminary hearing involves a prosecutor demonstrating to a judge why the charges have been filed and justification to continue. At a preliminary hearing, if the judge does not believe that there's enough evidence, then the judge can release the person. So a preliminary hearing is very important because the prosecutor has to demonstrate that the person that they have in the courtroom did the crime, and here's the justification of why we need to continue with the process. The grand jury is basically the same, but grand jurors are made up of lay persons, of persons that have nothing to do with the law. Just basically anybody can be on a grand jury. They come together and they're selected to find evidence to bring to the judge to say that this person has committed this crime and we should continue. So grand jury and preliminary hearing, same thing, just different types of people that are involved in that. Okay, some terminology for you. There's 4 pleas that can be made in California, and they are guilty, not guilty, no contest, and guilty by reason of insanity. And the plea that is used least often is guilty by reason of insanity. It's used the least. The most used is not guilty. Other terminology, plea bargaining. Basically, a person's charged with several crimes, several serious crimes, and the prosecutor decides that they would like to not go with those serious crimes, go for lesser crimes because they want to offer the person a plea bargain. So they guarantee a conviction. A plea bargain is still a conviction. So if you plea bargain down from murder first to manslaughter, that's a plea bargain. You're pleading to a different charge. It's still a conviction. But who benefits? Who benefits in a plea bargain? Does the accused benefit? If you plea bargain down from a murder to a manslaughter case, or say a rape to a child molest case, but you did not do it, but you plea bargain to it, does that benefit you? A lot of people will not plea bargain to something they did not do. They would rather go to trial. Does the community benefit? If a person is charged with murder, but they plea bargain to manslaughter, it's 12 years in prison as opposed to 25 years to life. So does the victim and the community, or the victim's families, do they benefit because the person gets less time? So again, there's a lot of benefiting. Who benefits with a plea bargain? One thing about a plea bargain, if you plea bargain, you agree to a plea bargain, you sign that piece of paper, you will give up your rights to an appeal. Very important. A lot of inmates, or many inmates on death row, who go the full trial because of murder first degree, they appeal their cases, and every once in a while their case has been dismissed because of evidentiary issues. So again, if you agree to a plea bargain, you give up your right to an appeal. That's a very important right that we have. A lot of people do not like to do that. Pretrial motions we're going to go over in a second. Discovery is basically each party obtaining evidence from the other party, or by parties by means of discovery, such as documents, interrogations, interviews, admissions, and depositions. Discovery is very important because both sides need to have the same information. So if the defense finds a witness and has an interview and tapes it, they have to give that information to the prosecutor. So they have to share information. If the information is not shared, then it could taint the trial. So it's not fair and in balance with our criminal court system. Witness testimony, you swear or affirm. Why do you raise your hand when you swear or affirm? Because in the medieval days and days earlier than that, a person would put their hand on a Bible, their left hand on a Bible, raise their right hand to show the court and everybody in the court that they had not been convicted of a crime. Because back then they would brand the right hand, the right palm of a person after they've been convicted of a crime. So everybody would know that that person was a prior convicted person. So that's the history of swearing and raising your right hand to show everybody your palm that you have not been convicted and you can be believed. So, a little history for you there. Some of the motions that are popular. First of all is the motion to dismiss. And again, usually the defense likes to do that because they want to dismiss on various reasons. Lack of evidence, eyewitness testimony. Sometimes it is granted, many times it is not. Motion to determine the competency of the accused. So that means that they have to go before a psychiatrist or a psychologist to ensure that the person is competent. They may have some mental difficulties. They may not have an IQ that is to the level of the court's liking. So the competency of the accused is a very important motion that can be used. Or the person is too young to understand, or they're mentally ill, or they're taking psychotropic medication. So that is a very popular motion. Motion to suppress evidence. That's obtained through an unlawful search or seizure, part of the fruits of the poisonous tree. If evidence is gathered in an illegal way, it can be set aside and not used. So suppressing that evidence helps one side or the other. Motion to suppress confessions, admissions, or other statements. That comes into play when someone has been Mirandized or not, and there's a taped confession or an admission or something written down that is made to the police. And a lot of times when juveniles or even adults, they are falsely accused, and they then, during the interrogation, will lie just to get out of the situation and admit to the crime. So these are false things that they would say just to stop the process. And these are very popular motions because sometimes people are coerced into admitting things that they did not do. So it's a false confession. Motion to require the prosecutor to disclose identity of a confidential informant. Confidential informants, there's a lot of rules and regulations about how you can use that person, if they are paid, if they have provided information in the past. But the identity of a confidential informant is very important because if they're not identified, then who are they? Who knows who they are? So usually that's a very important motion to use. So all of you attorneys out there that are going to be attorneys, these are some important things for you. Motion for a change of venue. When there is a case that has just been saturated in the media, in the news, in the local community, a motion is used by the defense to move the trial to a different location, literally 100 miles, 200, 400 miles away. And it's interesting because everybody's heard about a lot of cases right now that we're talking about, and moving it to a different place doesn't necessarily mean that it's going to be a fair trial, because usually everybody has heard about a lot of these cases. So unless you've been living on a rock, under a rock somewhere, you have heard about it, and it could taint the potential jury member. And then motion for continuance, that means that there's not enough, either side have not had enough time to gather evidence, to take care of their client, to discuss issues, so they ask for a continuance in the trial. This is usually done with serious crimes, murders, rapes, things like that, because of the complexity of the crimes and the amount of information that's needed. So those are the motions, the most popular motions that are used in court trials. The voir dire process is the final step in jury selection. During this process, the prospective jurors are questioned by a judge or attorneys to determine their suitability for serving on a jury. The voir dire process, very important process. Unsuitable jurors are dismissed in one of two ways. You can be dismissed because of cause, or you can be dismissed for peremptory challenges. And these options are designed to promote the semblance of an unbiased jury. So basically, you can be dismissed because one side, prosecuting or defense, does not think that you're going to be a juror that's going to be unbiased. Say an African American is on trial, maybe they would like to have a lot of African Americans on the jury. You're not African American, they may get rid of you because of cause. They can just say because of cause. Now, when we look at these things, when it comes to identifiable bias or a juror's apparent inability to judge a case fairly, they can file for a challenge for cause. So if someone comes up there and says, I am Hispanic and I don't like any other race, they're obviously going to get rid of that person, and they're going to challenge for cause because they are not an unbiased juror. The peremptory challenges, this enables attorneys to eliminate unfit or inappropriate people without justification. So they can just dismiss you because they don't like you, they don't think that you're going to be a good jury member. They can dismiss you just because whatever. They don't have to give a reason. Okay, they say thank you for your time, good luck to you. You've been relieved of your duty today of a jury member. So the limits, though, are 10 peremptory challenges in a criminal trial and 20 peremptory challenges in death or life cases. So you can get rid of a lot of people, but you only have a certain number that you can use for peremptory challenges. So selecting a jury is very tedious and very detail-oriented. We'll talk about the Titus Yates case at a different time. Jury nullification. Sometimes jurors fail to reach an agreement on a verdict due to jury nullification, which is the practice of jurors acquitting particular defendants despite strong evidence suggesting guilt. Jury nullification. So a jury can do whatever they want when they are deciding the guilt or innocence of a person. Would you want 12 people in charge of you to find out if you're guilty or not, or would you rather have just a judge do it? Again, if jury says, you know what, looks like he's guilty, but I don't think he's guilty. They can go with what they think, not necessarily the evidence, because the jury can do what they want. One thing about a jury, though, since the judge has the final say in all courtroom activities, if a jury finds a defendant not guilty, the judge, if he or she sees things differently, he or she can nullify that juror's verdict and find the person guilty. So the judge can change the verdict of the jury. It's rare, but it does happen because the judge has final say. Primary purposes of criminal sanctions. We talked about rehabilitation, attempts to fix or cure somebody because they're ill. Retribution is eye for an eye or just deserts. It's punishment based on the old biblical term. Deterrence is dissuading the offender or offenders from committing future crimes, making an example of somebody. Incapacitation is putting somebody behind bars in a physical structure so they don't commit similar crimes. The only thing about incapacitation, that's a great deal. You put somebody in jail or prison, but they can still commit crimes in jail or prison. So they don't necessarily stop committing crimes. They just don't do it in the community during their incapacitation. So, which sanction is hardest to measure? The effectiveness of? Which one do you think out of those? They're all effective, but which one would be the hardest to measure? That would be deterrence. Deterrence is very difficult to measure. Courts and multiculturalization, sentencing issues. Is there discriminatory sentencing? Are there biases in the court system when it comes to sentencing? Everybody has their biases. Do they bring them to the court, though? California sentencing structures include determinate sentences. A determinate sentence is a set time, such as 3 or 6 years. You're sentenced to 3 years in prison. That's a determinate sentence. The other type of sentence is an indeterminate sentence, which is a range of years. So you are going to be sentenced to 15 years to life or 7 years to life. So it's a range. And then we have a mandatory sentence, which is the 3 strikes law. It's mandatory, 25 years to life. Is that fair? Between 1993 and 1995, many states imposed this version of 3 strikes and you're out toward repeat offenders. 3rd felony. This worked for a little bit. It got some people off the street, but what it did is it punished people for a crime that they haven't committed yet. So they have 3 strikes, and on a 3rd strike you go away 25 years to life because they think that you're going to continue to commit those crimes. So there's a lot of controversy about the 3 strikes law. So read about the 3 strikes law. It's kind of important. A lot of people were locked up for non-violent felonies for their 3rd strike until that was changed. Courtroom personnel, who's in the court? Is there diversity in the court? Is there a need for diversity in the court? Has anybody in this class ever been to court and seen who is in the courtroom? Who operates the court? Is the judge, are they African American? Are they Caucasian? What did the personnel look like? What was their ethnicity? What was their gender? The representation is very symbolic of a courtroom. Judge usually sits higher than everybody else because they're the person in the court that has complete control. Underrepresented groups are usually, hopefully, there's some affirmative action programs that are used. These are some of the organizations and associations that promote women, cultural, racial, and ethnic groups in the court. So you can see there that a lot of attorneys and judges belong to these groups depending on their different issues that they have. So there's a lot of good things out there promoting different groups. Okay, some questions for you are right here. Go ahead and answer those questions. You don't need to turn those in, okay? But you may see these again in an exam or a position paper or something like that. So again, just take your time, answer these questions. Again, don't turn them in. But if you do have questions about this presentation, go ahead and place on the discussion board or email me. All right? Any questions? If not, thank you very much, and we'll talk to you soon.